podcast episode, The Waqf Act, What Did the Supreme Court Say? Hey listeners, welcome back to Legal Stories with Host. I'm your host, and Dust, and today we're diving into a juicy legal battle that had everyone talking, the Supreme Court case on the Waqf Amendment Act 2025. Man, what a case. Picture this, the Supreme Court of India, petitioners saying the new law is unconstitutional, the government defending it like their life depends on it. What was the deal? What evidence did they look at? What went down in the courtroom? And what does it mean for the public, Waqf boards, and the government? Let's break it down, step by step. Part 1. What was the case about? The background and challenge. So here's the deal. In 2025, the government passed the Waqf Amendment Act 2025. For those who don't know, Waqf is property dedicated by the Muslim community for religious, charitable, or social purposes. Think mosques, graveyards, or community schools. The old Waqf Act was from 1995, but the government felt it wasn't cutting it anymore. They said there was misuse, like people claiming government land as Waqf, fake Waqf properties, or mismanagement by Waqf boards. So, they brought in this new act with stricter rules, mandatory registration, protection for government properties, and even allowing non-Muslims in Waqf boards and councils. Big changes, right? But not everyone was happy. The petitioners, mostly Muslim organizations and individuals, went to the Supreme Court and said, "Hold up, this act is unconstitutional." They argued it violated Article 14, equality, Article 15, no discrimination based on religion, and Articles 25, 26, religious freedom. They had issues with specific stuff, deleting Waqf by user, where long-term use makes a property Waqf, giving the government power over Waqf disputes, and including non-Muslims in Waqf management. They wanted the whole act stayed, put on hold. The government, represented by Solicitor General Tushar Mehta, came in strong. They said, "Nah, this act is necessary to stop misuse." They brought up examples. In Andhra Pradesh, Waqf boards claimed 1654 acres of government land, but courts rejected it. In Telangana, there was a hotel dispute tied to Waqf claims. They pointed to history misuse going back to 1923, when people used Waqf to dodge creditors. The Joint Parliamentary Committee, JPC, had consulted stakeholders, and even the Archaeological Survey of India, ASI, complained about Waqf boards interfering with protected monuments. The government's stance? This act protects public interest, not attacks anyone's rights. The court looked at evidence like the legislative history, 1923 to 1995 acts, the 1976 Waqf Inquiry Committee report, which pushed for mandatory registration, old court judgments like Siddique versus Mahant Suresh Das, the Ram Janmabhoomi case, and government affidavits showing misuse cases. The petitioners argued it was an attack on religious freedom and discriminatory. The government countered that Waqf management is secular, not religious, and the act has a presumption of constitutionality. Part 2. What went down in court? The analysis. The Supreme Court bench Chief Justice B.R. Gavai and Justice Augustin George Massey dug into every section of the act. Here's what they concluded. Section 3. R. Prove 5 years of practicing Islam to create a Waqf. The court said this seems fine to prevent misuse through conversion, but there's no clear mechanism to prove it. So they stayed this section until rules are made. Section 3C. Government property can't be Waqf. The court agreed that public property needs protection, but they stayed the proviso, no Waqf status until a report, and subsections 3, 4, revenue record changes, saying only tribunals, not revenue officers, can decide titles. Section 3D, protected monuments can't be Waqf. The court said this is okay since ASI had issues, and religious practices can still continue. Section 3E, no Waqf in tribal areas. The court found this valid to protect SC/ST rights under the 5th and 6th schedules of the Constitution. Sections 9 and 14, non-Muslims in councils and boards. The court said it's fine since the functions, financial survey, are secular, but limited non-Muslims to a max of 4 in councils and 3 in boards to keep Muslim majority. Section 23, CEO appointment. Fine, but try to appoint from the Muslim community. Section 36, mandatory registration, no suits for unregistered Waqf. The court said this is needed based on history, with a 6-month window for registration. Courts can extend. Section 107, Limitation Act applies. This was upheld to remove discrimination. Sections 104 and 108, deleted. Fine, as they didn't align with new definitions. Final takeaway? The court didn't stay the entire act but put specific sections on hold. This is a prima facie opinion, and things could change in the final hearing. Part 3. What are the rights now? Public, Waqf, government. So where does this leave everyone? Public, community rights. If a property is a valid Waqf, you can use it, like praying in a mosque. But you can't claim government property as Waqf. Tribal areas are protected for SC/ST communities. Government property stays safe in the public interest. Waqf boards, mutawali rights, register your Waqf, or you can't file suits after 6 months. Government property claims go to tribunals. Boards keep a Muslim majority. Don't create third-party rights during pending inquiries. Government rights. They can protect their property. Inquiries are done by officers above collectors, but tribunals decide titles. ASI controls protected monuments. In Delhi NCR, the NCT Delhi Waqf Board is under these rules. Got a Waqf property dispute, say in Old Delhi? Head to the tribunal or high court. Part 4. What's the lesson? And court orders. What did we learn? When making laws, look at history and misuse. Religious freedom matters, but so does secular management. Muslim community. Take registration seriously, or you might lose rights. Government, prove your property claims. It's all about balance. No grabbing, no misuse. Court's judgment and orders. No stay on the whole act, but specific parts, like 3C proviso, 3R's 5-year clause without rules, are stayed. Directions. Limit non-Muslims in boards, councils. No third-party rights in pending cases. Try Muslim CEOs. Final hearing is still pending. Outro music. What a case, right? If you want more details or the next episode, like when the final judgment drops, drop a comment. Subscribe, share, and stay tuned for more legal dramas. Catch you next